Hello, this is Levi and Salomon's video series on Brazilian antitrust law. We are here to talk about the prosecution of cartels in Brazil. We all know cartels consist of illicit agreements between competitors. In practice, it can take the form of an agreement to divide the market, to fix prices, or even to determine output. CADE, as well as other competition authorities, has been keeping its promise to strengthen enforcement and step up sanctions against cartels. In order to conclude that there has been illicit cartel activity, CADE only needs to prove that the collusive conduct took place. That means that CADE needs only factual evidence of an agreement or coordination between the companies, such as minutes of meetings, wiretaps, and messages exchanged between competitors. CADE does not need to demonstrate that the conduct had actual effects because under CADE's practice, the anti-competitive effects of a cartel can be presumed. Still, a cartel can only be prosecuted in Brazil if CADE can demonstrate that it is capable of at least producing potential effects within the country. According to CADE's practice, an international cartel will fulfill this requirement if its geographic scope includes Brazil or a region encompassing Brazil, such as Latin America. This occurs, for instance, if the cartel involved products that are exported to Brazil, or when the cartel allocates sales to Latin America to certain cartel members. A company found to have participated in a cartel with effects in Brazil is subject to fines of up to 20% of the company's or group of companies' pre-tax turnover in the economic sector affected by the conduct in the year prior to the beginning of the investigation. In order to ensure that the sanction will be proportionate to the specificities of the conduct, CADE considers a turnover only in the fields of activities of the cartel. Also, fines are doubled in case of recidivism. Officers and directors can be found liable for the cartel if CADE determines that they acted with fault or negligence, and in such case may be fined up to 20% of the amount of the corporate fines. Other collaborators, such as company employees with no decision-making authority, business associations, and other entities that do not engage in commercial activity may also be fined up to approximately 2 billion reais.
Apart from fines, CADE may also adopt a number of severe punitive measures against companies and individuals. Examples of these include ordering the publication of a decision in a major newspaper at the wrongdoer's expense, prohibiting the wrongdoer from obtaining public funds from financial institutions up to 5 years, or from participating in bidding procedures, and also recommending that the tax authorities block the wrongdoer from obtaining tax benefits. Also, CADE can determine that individuals found guilty of cartel be disqualified and banned from undertaking market activities individually or on behalf of a company for 5 years. Finally, Brazil's enforcement system against collusion is dual, that is, a cartel is both an administrative infringement and a crime. Therefore, an individual found guilty of cartel can also be subject to criminal penalties, including a criminal fine and 2 to 5 years imprisonment, which may be increased by up to 1/2. There is no criminal corporate liability for cartel crimes in Brazil, though. Brazilian federal and state prosecutors are in charge of criminal enforcement in Brazil. Even though they act independently from CADE, administrative and criminal authorities have been cooperating closely to enhance cartel detection and also to preserve incentives for the leniency program in Brazil.